1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်255 The Bank of Communication Plaintiff vs KHYN Company Defendant ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Regular Suit before ဦးကျော်ဆန်းဦး Judge The Bank of Communication Plaintiff vs KHYN Company Defendant Suit for recovery of loan on a promissory note debt bar by limitation acknowledgement of the loan with a promise to pay whether the document is a pronote or an acknowledgement of the debt, a promise to pay a bar debt comes under Section 25, Subsection 3 of the Contract Act, whether to be stamped under Number 5 C of Schedule 1 of the Burma Stamp Act as amended by Act Number 28 of 1957, whether admissible in evidence. Held, reading the document Mark B as a whole, it is held that it is a promise to pay a bar debt under subsection 3 of section 25 of the Contract Act because it 1. is in writing 2. signed by the defendants 3. expressing a promise to pay 4. the bar debt referred to therein. It is more than a mere acknowledgement under Section 19 of the Limitation Act. It is primarily an acknowledgement with an express promise to pay the time bar debt due on the promissory note Mark A. date 9 July 1954 and the defendants had notice of it. Mortgage Insurance Corporation Limited vs. Commissioners of Inland Revenue 1881 20 QBD 645 Mohammed Akbar Khan vs. Atta Singh 63 IA 279 PC Gampat Das Kaludas Gosai vs. Harivallabh Onkhaji Trivedi ILR 1942 Nagpur 126 Ghulam Muriaza vs. MT Farsi Anisa BB ILR 57 Allahabad 434 Gobhai Das and others vs. Saju Das ILR 30 Kalakata 268 Sayaketu Dada vs. Ramesh Chandra Sen ILR 60 Kalakata 714 referred to held also the document Mark B have been held to come under subsection 3 of section 25 of the Contract Act, which begins with the words an agreement and is to be stamped under number 5C of the Schedule 1 of the Burma Stamp Act as amended by Act number 28 of 1957. As it now stands, it is not admissible in evidence for not being sufficiently stamped, but under Proviso A2, Section 35 of the Burma Stamp Act, read with Section 33(1) of the Act and Proviso B to subsection 2 of the said section and Also, paragraph 263 of the High Chief Court Manual, it can be admitted in evidence on payment of the deficient duty together with the penalty required. David Sutherland Clark vs. Ruth Crimshaw, AIR 1923, Lahore 481, Prasanna Kumar Pe and Sanatan Guna vs. Panula Miji and another, AIR 1923, Kalagata 659, refer to Saw Take Law for the plaintiff, Mao for the defendant. Ujosan Judge, the material facts are these. On 9 July 1954, the plaintiff bank lent Jet 75,200 with interest to the defendant firm on a promissory note marked A. After the debt had become barred by the law of limitation, the defendant firm wrote to the plaintiff bank on 15 July 1958, acknowledging the previous law on the promissory note and the interest due, expressing at the same time that they promised to pay within a short time. This letter mark B is stamped with the 20-pia stamp. When the defendant firm failed to pay as promised, the plaintiff bank sent a legal notice on 2nd May 1961, wherein it states that the aforesaid on-demand promissory note became time-barred and the said King Company signed an acknowledgement date 15 July 1958, acknowledging that they owe my said clients the sum of debt 75,200 plus interest up to date due on their on-demand promissory note date 9 July 1954, and at the same time promise to repay the same within a short time. Please treat the aforesaid notice of mine as claiming the sum of debt 85,934 and plus 65 only, as due on the acknowledgement and promise to pay a time-barred debt date 15 July 1958. As no payment was made in spite of the aforesaid notice, the present suit was instituted for the recovery of debt 85,934 plus 65 due on acknowledgement of and promise to pay a bar debt with interest thereon at the usual court rate from date of suit till realization with cost. In the plain, it was stated that demands had been made for payment but to no avail. The defendant firm, in their written statement, admitted execution of the promissory note mark A but denied consideration as regards the letter mark B date 15 July 1958. They stated that it is not an acknowledgement but a promissory note, which is not admissible for not being sufficiently stamped. No reference whatsoever was made in the written statement to the demands made by the plaintiff bank. This document mark B date 15 July 1958 is as follows. Dear sirs, we, the undersigned, acknowledge that we own the sum of debt 75,200 only, plus interest up to date to the Bank of Communications Rangoon, due on the promissory note, date 9 July 1954, executed by us, and we hereby promise to pay the same within a short time. Yours faithfully, Burma. 15 July 1958, King Company. By consent, the following three issues were framed and, before taking oral evidence, the second and third issues were argued as preliminary legal issues. This order relates to these two issues. Issues 1 was the promissory note, date 9 July 1954, executed for consideration. 2 is the document marked B, date 15 July 1958, a pronote or an acknowledgement of the debt due on the bar, pronote, date 9 July 1954. 3 is the document marked B, date 15 July 1958, admissible in evidence for not being sufficiently stamped. Reading the document marked B as a whole, I'm of the opinion that it is a promise to pay a bar debt under subsection 3 of section 25 of the Contract Act because it 1 is in writing, 2 signed by the defendants, 3 expressing a promise to pay, 4 the bar debt referred to therein, shown of the was not relevant for the purpose of this suit. Subsection 3 of section 25 runs as follows. An agreement made without consideration is void unless it is a promise made in writing and signed by the person to be charged therewith to pay a debt of which the creditor might have enforced payment but for the law for the limitation of suit. If the parties meant it to be a promissory note, they would have used the usual promissory note form beginning with the words on demand, we, the undersigned, etc., as in the note marked A. If the document marked B was meant to be a promissory note, it would have been without consideration, but for the reference made to the previous promissory note, mark A, which was a bar debt, quoting the observation of Pollock B in Mortgage Insurance Corporation Limited versus Commissioners of Inland Revenue 1, where the learned Baron said, I think it is clear that for the purpose of the Stamp Act, it cannot have been intended that a document should be treated as, in part, a promissory note and, in part, as agreement. It must be either one or the other. The question is, what is the dominant, the substantial effect of the instrument? In this respect, the Para decision assists me in forming a conclusion. The courts have said that in order to determine the question, two things must be inquired into. What is the intention of the parties, and what is the instrument in the common observation of man of business or person among whom it is commonly used, and alluding to Muhammad Akbar Khan versus Adar Singh to Niyoji Judge in Kampadas Kaludas Gosai versus Harivala Onkaji Trivedi 3 said, the test is not that the instrument contains a promise to pay, but whether or not the parties clearly intended the document to serve as a negotiable instrument. It is consequently necessary to look into the terms of the document and the surrounding circumstances to see whether it was intended to be a promissory note in the sense of its being intended to be used as a negotiable instrument. It is a well-recognized rule of construction of documents that they must be construed as a whole, that every part of the documents must receive attention, and that the intention should be gathered from the whole contents of the instrument so as to make one entire and consistent construction of the whole. I entirely agree that issue number 2 in question must be decided on the intention and the real characteristic of the document. Mark B. Emphasis was made on the bad debt and the express promise to pay the same. The legal notice referred to above and the plaintiff are more than clear that it was meant to be a document acknowledging clear previous bad debt with an express promise to pay the same, and like an acknowledgement of liability under Section 19 of the Limitation Act, which must be made before the expiration of the period prescribed for payment of the debt. The express promise for payment under Section 25(3) of the Contract Act must be made after the expiration of the period prescribed for payment of the debt. Gulam Mataza vs. MT Fasianisa BB4 in Gobind and others vs. Saju 5, it was held that while it is sought to recover a time-bound debt on the strength of a subsequent promise to pay made in writing by the debtor, the document relying on must contain an express promise to pay under Section 25(3) of the Contract Act. See also Sayakadu Data vs. Ramesh Chandra Sen says, I'm of the opinion that the document Mark B is more than a mere acknowledgement under Section 19 of the Limitation Act. It is primarily an acknowledgement with an express promise to pay the time-bound debt due on the promissory note Mark A, date 9 July 1954, and the defendants had notice of it. The next point to be determined is whether this document date 15 July 1958 and Mark B is admissible in evidence for not being sufficiently stamped. I have held above that it comes under subsection 3 of Section 25 of the Contract Act, which begins with the words an agreement. It is stamped with the 20 stamp, an agreement under the Burma Stamp Act as amended by Act number 28 of 1957 is to be stamped with the 3-jet stamp under number 5C of Schedule 1 of the Act. There is, however, a conflict of authorities on the point. In David Sutherland Clark vs. Ruth Grimshaw 7, the bench of the Lahore High Court, referring to Section 25(3) of the Contract Act, held that a written promise to pay a bad debt is not required by any of the provisions under the Indian Stamp Act to be stamped. With due respect to the learned judges, I do not agree. I think the words an agreement appearing at the beginning of the session when overlooked. The bench of the Calcutta High Court in the same month of the year in Prasanna Kumar Bill and Sanatan Kuna versus Panula Miji and another 8. However, held that a document under Section 25(3) of the Contract Act is an agreement within the meaning of Number 5, Clause C of Schedule 1 of the Indian Stamp Act. I am inclined to agree with the view of the Calcutta High Court. The document in question, as it now stands, is not admissible in evidence for not being sufficiently stamped under Proviso A to Section 35 of the Burma Stamp Act, read with Section 33(1) of the Act, and Proviso B to Subsection 2 of the said section, and also Paragraph 263 of the High Chief Court Manual. It can be admitted in evidence on payment of the deficient duty, together with the penalty required. The learned registrar of this court, as the officer to whom the duty is delegated in this respect, shall comply with the requirements of law and the rule mentioned above and resubmit the record at an early date to the court for consideration of the remaining issue numbered 1. If the plaintiff bank fails to pay the deficient stamp duty and the penalty within the time fixed by the learned registrar, the document marked B, date 15 July 1958, shall stand rejected as inadmissible in evidence. Courts shall follow the event